Mr. Quraishi, good evening. There's been a lot of back and forth, sir, on the legality of this move, on whether we jumped the gun with the disqualification. What do you think, sir? Legally going by what's happened and previous precedents as well, what do you make of this development? Was this step expected? Was Rahul Gandhi going to be disqualified, or could this have waited?
Legally speaking, as soon as the court passes a verdict of disqualification kicks in immediately after there's a Lily Thomas judgment. But Lok Sabha Secretariat and Election Commission acting in haste or not so, that is the question. Now, if you see the Lakshadweep case a few months ago, very quickly Lok Sabha came into the act, and within 24 hours they disqualified an MP and asked for a by-election. And the Election Commission also was very smart, and they ordered the by-election. And then Kerala High Court stayed the conviction, and Supreme Court of India stayed the by-election.
Exactly.
But but interestingly, same Lok Sabha Secretariat, which was so smart and quick and efficient to issue an order of disqualification within 24 hours, has not acted on the stay on conviction by the Kerala High Court, despite the advice of the Law Ministry. So this selective efficiency doesn't reflect very well on the Secretariat of Lok Sabha.
So you made a very interesting point when you said selective efficiency. But what I want to understand from you, Mr. Quraishi, is there automatic disqualification in these cases? When there is a member of parliament or a member of a legislative assembly who is convicted in this matter, is there automatic disqualification?
Yes, exactly. That was the wording of the Lily Thomas judgment, that as soon as somebody is disqualified or convicted, the disqualification is automatic. Similarly, when that conviction is stayed by the court, the removal of the disqualification should also be automatic. They are being selective. That is the point I am trying to make, because Election Commission, mind you, if there is a vacancy. Now, if there is no stay on this conviction, the vacancy is bound to take place. It will have to be filled. But Election Commission has always 6 months to fill up a vacancy. They have all the time in the world, up to 6 months. Now, if someone, suppose within 24 hours, 48 hours, they say we want the by-election, this will not reflect very well on them. So, of course, when you know the other party is going through the legal process, and what will be the situation when some court, after you have issued the disqualification notification, after Election Commission has issued a notification for by-election, and the next day the court stays the conviction, you have to take back everything. So it will be very awkward and embarrassing, and these optics are extremely important, because one should be more dignified, because if law will take its course in due course, but to do it in undue haste doesn't reflect very well.
Sir, you've raised some very, very important points. My other question to you, sir, and there have been questions being asked right now by the Congress on this, on what is the procedure, what is the process that is to be followed in this circumstance? Is it something under Article 103 of the Constitution that the President must okay? Is that the case, Mr. Quraishi? That do you believe that in the disqualification of Rahul Gandhi, due procedure wasn't followed?
No, I don't know. I haven't gone into the judgment whether the judgment was correct or not. Of course, that is for the lawyers of Rahul Gandhi to see, and they will be, of course, questioning, challenging it. I am only on the basis on this point that after the Lily Thomas case, the disqualification kicks in automatically. Earlier, the 3-month period was provided under Section 8 of Representation of People Act, which was found unconstitutional as discriminatory. You and I, if we have been convicted, we cannot contest. But here was an MP or an MLA, once convicted, he could, first of all, the 3 months are given, and then he will go in appeal. And during the process of appeal for 10 years, for 15 years, the disqualification did not operate. That is what Lily Thomas case said, that it has to come in immediately and automatically. So therefore, in this case, automatically, at this moment, he stands disqualified. But where was the hurry for the Lok Sabha to issue the notification today, but that was undue hurry. And undue hurry surely is a bad optic for me.
And let me just remind our viewers, Mr. Quraishi, that this notice didn't come today. It came yesterday, the moment Rahul Gandhi was convicted. But Mr. Quraishi, can you explain also, for the benefit of our viewers, what are the options ahead for Rahul Gandhi? Because he does have a few to actually appeal this disqualification.
Yes, of course. The only thing is it has to be fought in the court of law, not on the street. If they are doing it, that's wrong. It should be in the court of law. They should challenge the conviction on whatever grounds are available. And if the court stays the conviction, not the sentence, mind you, that is one another thing which people are confused. Suspending of sentence was done by the convicting court itself, by giving him 3 months, 30 days to file an appeal, and for 30 days he will not be arrested. So that sentence was suspended. But conviction has to be suspended for this disqualification clause to become non-functional.
Okay, this has been very, very helpful. I'm sure this conversation also gives our viewers the perspective, the much needed perspective on whether this disqualification was fair or not. Thank you very much, Mr. Quraishi.